And sometimes when USCIS sees that the basis for that wage survey is not very good, we do see these RFEs. So the most common RFEs that we see are typically either the wage level is inappropriate, or sometimes somebody is utilizing an own it code, the occupational code, that has a lower salary. Suppose somebody is working as a software developer, and the duties are all software developer job duties, but somebody goes and claims that he's a software programmer, computer programmer, own it code. USCIS, they will dig into the job duties, and sometimes we see RFEs where they say you use the own it code that is not appropriate. The own it code that you used has a lower salary. That is not appropriate. So that is also very important. And to avoid these kind of RFEs, what needs to happen is make sure you're using the right occupation, you're using the right wage level, and using the right wage source. So if you don't ensure that the right own code is used, the right wage level is used, and the right uh, uh, appropriate job duties are used, more than likely you're going to be hit with this kind of an RFE. And wage level RFEs are typically pretty complex. The way to avoid it is be very thorough in the initial time of your filing. Ensure that USCIS does not even question your occupational code or the wage level.
There you go, friends. Thank you so much, Chand, for taking that up and for the detailed explanation. I'm sure folks have questions as well, so keep commenting, I would say. And uh, yes, moving on, Chand, let's go on to our next one. So, what kind of documentation will USCIS require, if in an RFE to confirm the location of the H-1B work site, if the beneficiary is working remotely or in multiple locations?
Sure. I mean, the good thing that we have been seeing in the last couple of years is USCIS has been pretty liberal if people want to work remotely from their home. And USCIS has also been liberal if people want to work at multiple locations. And the reason for that is ever since COVID, a lot of companies want people to work in their home. They also want them to come and work at their location as a hybrid model. So, full remote, 100% remote, where they're working from home, or hybrid model where you go to your location, your work location, like maybe once a week, twice a week from your home. So these kind of this kind of work pretty common in the recent few years. The good thing is USCIS has been pretty liberal. They don't have a problem if people want to work remotely or work from multiple locations. However, from a USCIS perspective, they are very particular about the prevailing wage requirement. They're also very particular about employer-employee relationship. And in terms of when we see the RFEs, we do see RFEs where they talk about the worksite address, the address that you have as your worksite address. USCIS will definitely want to see what that address is. We have seen a number of RFEs where they come back and say sometimes this address looks like a residential address. This address looks like it is a virtual office. And they do come back with those kind of RFEs. And what we need to prove is we need to prove that employee has the right resources to work at that location. If somebody is working remotely, that is okay. We do need to show that the H-1B worker, does have enough resources to work from that location. And what that means is when somebody is working from a remote location, remote home location, things like showing that somebody has a lease, somebody has proper internet, proper workspace. Sometimes you have to show photographs of workspace, even if it is remote. So we use these kind of documents to prove that there is enough workspace at the location, even if it is remote. And sometimes USCIS, they ask for clarification of the work site. Maybe when USCIS Googled that location, it showed up as a virtual office. Maybe they felt that this might not even be a right location. So they come back and hit us with an RFE and say, our public search indicated that this could be a virtual office where multiple offices are located. Give us some more clarity. So these kind of RFEs are common. So what we do is whenever those kind of questions get asked, we try to show through a lease that you do have dedicated space. And a big part of the H-1B is the employee needs to have dedicated workspace at the location they're supposed to work. So this is pretty important. And another big thing is detailed job duties at each work site. So if you have multiple locations and if the employee is working at multiple work sites, we do need to provide the detailed breakdown at the job of the job duties. For example, if somebody is going to the client location to gather requirements, to do a bunch of meetings, and do the software development work from their home, for example. So we have to break it down and give a clear clarity on how do you break up multiple work sites? Because a lot of people do work from multiple work sites. Sometimes they have to go to the client location. Sometimes they have to go to their employer location. Sometimes from their home. So you might have three, four locations sometimes. And a part of the H-1B filing is to give that clarity. And if you don't give that clarity, sometimes we're hit with that RFE where they say uh, what are the percentage of job duties that you do at each location. So to avoid these kind of RFEs, explain how do you have supervision, how do you have control at these multiple work sites, how the employees are supervised, who retains the control, who gives the instrumentalities for their work, and so on. Explain it more clearly, because USCIS wants to know that employees are only being assigned specialized job duties. They're not being assigned non-specialized job duties. So as long as if as this clarity is given, clarity based on the work site, clarity based on the location, the job duties, etc., it should typically not be a problem. And the client letters for third party work sites. Lately, we are not seeing any RFEs for client letters when somebody is working at a third party work site. In the future, we don't know. But at least as of today, we don't really see letters asking for verification from clients about the work arrangements. Lately, it has not been happening. And in general, like for the work arrangement for remote work, because remote work is so famous nowadays, I've seen cases where USCIS could also ask about the company policies or procedures regarding remote work. Sometimes it's also a site visit where they ask about the company policies or procedures for remote work. So, always it is a good idea for the companies to document how the worker will be integrated into the company's operations while the employee is still working from a distance. It's also a good idea for all the employees to document how they're working remotely, things such as whose laptop are you using, and when do you connect, what kind of tools do you use to connect, do you use some kind of a VPN, some kind of a company tool to connect to your office, and so on. Keep all this documented. The reason is sometimes you get an RFE and you might need to show all these evidences. Sometimes there's a site visit, you might need to show all these evidences. And the last important thing is the prevailing wages when you have multiple locations. So the big thing is USCIS requires every worksite to have its own prevailing wage uh, uh, properly done on the LCA. So the LCA should list all the work locations, all the multiple sites. The LCA has to list all the offered salaries, because uh, uh, the salary might be different if somebody has two locations. If somebody has their client location, say in Austin, and their home location in Dallas. So what the LCA is supposed to do is the LCA is supposed to have both the work locations. The LCA is also supposed to prevailing wages for both the locations, and then be processed. So USCIS will ensure that the LCA does allow the employees to work from multiple work sites. So the proper prevailing wage on the LCA, the proper work location on the LCA, this is highly important. And as long as this is done, there is evidence of ongoing work. There is evidence of employers' ability to supervise remote workers, where either through a company policy, companies org chart, various policies, communication tools that they give the employees, and so on. As long as there is ability to supervise the remote workers, in general, it should not be a problem. We do see RFAs time to time, but the good thing is lately USCIS has been very liberal about work from home kind of options. In the future, I don't think anything will change majorly, because USCIS tends to agree to whatever are the industry standards. So unless something changes, decide where everybody is supposed to come back and work from their office, more than likely, I don't think we will see a lot of RFEs on remote work options in the future.
Okay, that's very interesting. Thank you, Chand, for taking that up. And by the way, do you know of any cases who have never received an RFE? Or is it like very common? Every case gets an RFE.
On the H-1B side, lately, most of the cases get approved directly. It used to be so bad a couple of years back, where pretty much every case which had a third-party work arrangement. Third-party work arrangement is like one of the most famous ways of filing for H-1B. What that means is you have one company who's your employer, maybe an IT services company, IT consultancy, or some other company such as a vendor. Then you have an assignment where you're working for the end client. So a third party work arrangement is where you're working for an employer, but the employer is not where you're actually working. You're actually working for some other ultimate end client. So those kind of cases every other case used to get an RFE a couple of years back. Those cases used to be so hard a couple of years back. But in the most recent 2 3 years, we are not seeing a lot of challenges with whether it's a full time offer where your end client and your employer both are the same, or whether you're working for a third party engagement. Both are equally, I think, getting approved pretty easily, at least lately. And if you ask me what is happening right now on the H-1B side, I would say most of the cases do get approved without an RFE. And the reason for that is the salaries are very high. The employees are qualified. They have master's degrees. They have bachelor's degrees, at least a bachelor's degree or an equivalent. So from a USCIS perspective, when you show all that evidence that the employee is qualified, you're paying such a high salary, and you do have an assignment, in general, the RFEs are low. That being said, every case is different. Sometimes USCIS is Googling about the company. Maybe they did not find the right information about the company, so they're issuing an RFE. Maybe they're looking at the employee. The employee has a lot of unemployment time during his OPT. So we are doing a change of status, for example, from OPT to H1. USCIS might issue an RFE. So depending on what exactly is going on, you still see a lot of RFEs. That being said, I would say majority of the cases do get approved without an RFE, at least lately, and hopefully that continues, because giving an RFE, and again, it's a lot of time wastage, both for USCIS, both for the company and everybody involved. So at least the clean cases, I think they will still continue to give direct approvals. Uh, so not every case gets an RFE, and again, if somebody gets an RFE, there is nothing to panic. So most of the RFEs get resolved. If you look at the H-1B side, the approval rate is in high 90s. So even if you get an RFE, more than likely the case will get approved. That being said, it's nothing to panic if you get an RFE. Look closely at what is in the RFE and try to respond back on time. The deadline is very important. For H-1B RFEs, you get 87 days to respond. As long as you send the response back, send all the documents back on time, you should not have an issue.
There you go. Remember, 87 days is your deadline, folks. So, yes, keep that in mind. And a delay may cause or will definitely cause a denial, right, Chand?
Again, if you don't meet the deadline, if the RFE, the 87 days pass and you don't respond back to the RFE on time, more than likely the case will get denied. So USCIS will
Okay.
say you have abandoned your petition, and they will issue a denial for abandonment.
Okay. Okay. Thank you, Chand, for the detailed explanation. Now, moving on, for H-1B applicants applying for a change of employer, what specific evidence is USCIS seeking, to validate the continuation of the same job duties?
Um, so when somebody is applying for change of employer, which is commonly called as a transfer. So if you're applying for a transfer, USCIS does not expect somebody to be in the same job as the current job. The reason is somebody might be working as a software developer, say in Microsoft, and say they lose their job in Microsoft. They're supposed to go and find another job in 60 days. So in 60 days, somebody might not find a same kind of a job. Sometimes maybe they will find a job that pays same or higher. Sometimes they might have to take a demotion, go to a lower level job, because in the industry there is no guarantee that you'll always find the same job that you have been working on when you move to another employer. And what that means from a USCIS perspective is, as long as the transfer, the change of employers petition qualifies for H-1B, even if the job duties are different. For example, somebody worked as a software developer. Now you might go and work as a software tester, a software quality assurance engineer, for example, in the new job. Maybe your salary is low. It is still okay as long as you still meet the requirements for specialty occupation, as long as the new employer is bona fide employer and they're willing to pay as per the LCA requirement, the case will get approved. So there is no requirement that it does have to be the same or similar to the previous H-1B. So USCIS normally does not go back and check and see what kind of a role they have worked in the past. They don't do that. However, what they do is they can always go back and make sure in the previous petition the employee did work as required. And what that means is looking at the pay statements. So it is very common they go back sometimes and say, produce all the pay statements of your previous employer. We want to check and make sure you maintained your status. That's a possibility. Normally what you do is you send 2 or 3 most recent pay stubs. But sometimes if USCIS feels that something is not right, they might go back and say, in your previous job, we want to see all your pay stubs, produce all the pay stubs. It's a possibility. Uh, that being said, what kind of role somebody had in the previous job might not matter much. That being said, in the current job, always document very detailed job duties, and the job duties should demonstrate that the duties align with the specialty occupation. It should also be consistent with the worker's qualifications. And so if you say my employee is going to work as a software quality assurance engineer, we also have to prove that the employee who's going for a transfer, change of employer, is also qualified. What that means is, if they have, for example, like a civil engineering background, and you're applying for a software quality assurance job, there is no nexus on a high level when you look at civil engineering and software quality assurance. But maybe the person has a lot of experience, IT experience. So you have to show the connection between the worker's quality and your role. Maybe it is through education alone. Maybe it is through a combination of education and experience. So you have to show that that nexus, and you have to show that this job is indeed a specialty occupation job. So that is very important, and you don't really have to do any kind of a comparative analysis between your old role and new role. It is not even required. All you do is give a very detailed explanation of your current role, the role with the new employer who you are filing for a change of employer. Give a very good, solid evidence about your educational background, about your experience background, about your prior experience, and that is what they look for. And make sure the prevailing wage is right, the wage level is right, the LCA is right. And if you do it, more than likely you should not have any problem with change of employer. So anybody who's filing for a transfer or change of employer, don't worry about the role being totally different. It is okay for the role to be different. There is no requirement that your wage level has to match in the new job. There is no requirement that the job duties have to match. Everything can be different. As long as the new job qualifies for specialty occupation, you should be good.
That's great. That's great news. Thank you so much, Chand, for highlighting that and for giving us a detailed explanation. I'd quickly like to say hello to our viewers who have commented and they have questions. We are going to address them very soon. Nidhi, thank you so much for joining us. Raghav and also Santosh. Hi to all three of you. Thank you for your questions. Please stay with us. Now, to go on, Chand, I have another question, and that is, if an H-1B petitioner is receiving an RFE about the qualifications of the beneficiary, what additional proof can be provided beyond educational transcripts to ensure a favorable outcome? I mean, you already touched upon this a little bit, but if you could just add on a little more.
Yeah, sure. So nowadays, if you ask me what is the most common RFE, a few years back, like about 4 years back, every RFE was about third party work arrangements. It was about services in specialty occupation. And RFEs were like so different, very commonly asking about right to control, employer employee relationship, and so on. Nowadays, in the recent times, most common H-1B RFEs are about beneficiary qualifications. So if an H-1B petitioner receives some kind of an RFE regarding the qualifications of the beneficiary, the H-1B applicant. So what USCIS is saying is, USCIS is saying, prove that your beneficiary actually meets the specialty occupation requirement and actually has that necessary qualifications. So what we are trying to show is, it is not just your educational transcripts, but show how your employee qualifies. And whenever we see that RFE talking about beneficiary qualifications, the first thing that we do is evaluation. So we have to evaluate the degree. And most of the time, if somebody has a foreign degree, somebody has a degree that is relevant to the job. Say, for example, somebody is applying for a software developer position, and somebody has a degree from India, a computer science degree from India. We know that it's the right major, it's the right degree because it's a computer science degree. So if you see an RFE for somebody that qualifies, but they just have a foreign degree, it's a very simple RFE. All you have to do is go to a reliable credentials evaluations agency. Simply ask the credentials evaluations agency to determine the US equivalency of the foreign degree. And these evaluation companies, they will evaluate the equivalency, and they'll give a equivalency from a US standard. So for example, if somebody has a computer science degree from, say, Usmania University in Hyderabad, for example, you can get an evaluation done where that degree is equivalent to a US degree, a bachelor of science degree in computer science. So, um, so these evaluation companies know how to do it. So you have to go to a reliable credentials evaluations agency and get a simple education evaluation done, and that's it. You submit this evaluation copy to USCIS. It takes care of the RFE, and this is a very simple RFE if you have the right degree. When I say the right degree, your degree actually is in the relevant field of your occupation. But again, there are a lot of cases where you get this RFE for beneficiary qualifications. They don't have the right degree. So, for example, somebody has a mechanical engineering degree, they have a civil engineering degree, or they have sometimes even like an electrical engineering degree, and the job is, for example, a software developer. So, from occupational outlook handbook standards, the common degrees are either computer science or information technology. So, anytime your degree does not match the degree that is relevant from an industry standard, what you're supposed to do is you're not only supposed to do an education evaluation, but you're also supposed to gather all your experience letters. So every experience that you have that is relevant to your job, you're supposed to gather it and submit it for a professor evaluation. And again, getting a professor evaluation is not difficult. If you have the right experience letters, you have all the educational documents, you submit it to the professor, a professor in the United States. You submit it to them and ask them to evaluate your degree. So there are a lot of professors who will evaluate your combination of experience and education, and you can submit that expert opinion. And USCIS will accept that expert opinion if that expert states that you have an equivalent degree in the relevant field when they combine your experience. It is a very common thing. And if you do have the right experience, most of the time, this is not a problem at all. So what we say is whenever you get this RFE, always that verification letter from your employer is very, very important. The challenge that we have is sometimes people come back and say, hey, this company in India will not give me an experience letter with the job duties, because it's a very common problem where a lot of companies will not put the job duties. They will verify the experience, they will not verify the job duties. USCIS requires the job duties. They want to know what did you do in your prior experience. So without the job duties, the experience letter is not valid. So in that case, what we ask the beneficiaries to do is we ask for affidavits. So you can go to a coworker. Even if your employer will not give you an experience letter, go to your coworkers or your team leads or your managers. Ask
Mhm.
them to give an affidavit in their individual capacity, simply verifying what did you do at the company. So an affidavit is also good enough. So sometimes it is affidavits, sometimes it is company experience letters. But as long as you have something to prove your experience, your job duties, that is enough. You can use those to go back to the professor and get an evaluation done. And by doing so, you should be able to overcome these RFEs for beneficiary qualifications.
That's great news. Thank you so much, Chand, for taking that up. And I think we should address some of our viewer questions now. So let's start with
Mhm.
Karthik Reddy B. If a person did bachelor's into 3 years degree into hotel management into OU, and he did MBA in business analyst in there, is there any RFE that will occur when H-1B filing?
So a 3-year degree is not enough, because for H-1B, you require a bachelor's equivalency from a US standard. So a 4-year degree or higher is what qualifies you for a H-1B. However, the good thing is you have an MBA. And when you have an MBA, MBA will be equivalent to at least a 4-year degree or higher in US. So what you have to do is you have to get an equivalency done. You get an equivalency done from a US standpoint. And in your case, what I would also suggest is if you have work experience, also try to get a work experience evaluation done, because a lot of times we see challenges with MBA because MBA is a business degree. And unless you have a concentration, like an MBA with concentration in like IT or marketing or sales, a general MBA sometimes is considered as a generic degree. And we have seen issues because of that reason. So, one thing for sure is definitely get an evaluation done for your case. And if you're able to gather all your experience letters, get a work experience evaluation done. And doing so, you should be able to overcome, as long as you have the right, either the courses taken in your MBA or the right experience that is relevant to your H-1B filing. And if you do so, you should be fine.
Great. All the best, Karthik. And thank you so much, Chand, for taking that up. Now let's go to Nidhi's question on YouTube. I'm planning to file an H-1B or an EB-2 NIW petition next year. With all the talk about RFEs increasing, how should I prepare differently? Are there any specific things people tend to overlook? And as an employer filing an H-1B for a highly skilled worker, what can I do upfront to avoid an RFE? Are there specific job descriptions or salary levels that draw more attention?
Sure. Again, I think the reason why people say that RFS could increase is because we have historical precedents. We had 2016 to 2020 time period where President Trump came into office and things changed. So back then, what happened was there were some USCIS memos. And after USCIS came out with some memos, what happened is they changed their adjudicating standards. So back in 2017, 2018, we had these memos talk about employer-employee relationships, especially services and specialty occupation back then. We also had these memos which talked about some professions not being specialty occupation, for example, like a computer programmer and so on. So those when those memos came out in 2017, 2018, what happened is the officers are supposed to follow the rules. And because there was an official memo, they changed their adjudication standards. And what that meant is an increased number of RFEs. We saw so many RFEs talking about and so many RFEs talking about employer-employee relationship because back then those memos required contracts, required client letters, required contracts from each and every party that was involved, and so on. And that was a lot of burden, and a lot of companies cannot give those documents. So that caused a lot of uptick in RFAs back then. And because of those historical reasons, people feel that if the adjudication standards change again because of some rule changes, we might see a lot of RFEs. So it's a possibility. And in terms of what do you do and how do you prepare differently, some cases are always going to be high triggers, and the reason for that is in the end, whether it is Biden's administration or whether it is President Trump's administration, I mean, the officers, what they're trying to do is they're trying to follow the rules, and the immigration rules. There is something called burden of proof. So, for example, for H-1B classification. So, for H-1B classification, we have to meet the burden of proof that is required for H-1B, and what that means is we have to prove that this particular job is a specialty occupation job. And there are ways USCIS does it. They look at the Own It online. They look at Occupational Outlook Handbook. So, for example, if you look at something like a web developer occupation, for example, in Occupational Outlook Handbook or Own It, or then you compare it with software developer, you will see that some occupations will require bachelors at entry level. And then, for example, like web developer, if you look at some occupations, for example, if you look at developer occupation on Own It online, you will see that at entry level, you don't require a bachelor's degree. So some occupations inherently, because of the nature of that occupation, inherently because there are standards, government standards that say at entry level you don't require a bachelor's degree, the scrutiny is very high. And there are some occupations where inherently it is accepted that they require a bachelor's degree. For example, a doctor or some professions, a dentist, some professions. You know that without a bachelor's degree, somebody cannot even enter that occupation. So USCIS will not even bother about issuing RFEs on specialty occupation for those RFEs. So lot does depend on your salary, does depend on the nature of that occupation, and so on, because you do have to meet the burden of proof. And if you don't meet the burden of proof, they'll upfront issue an RFE. And when it comes to ways to reduce the chances of an RFE, what you're supposed to do is, for example, you're looking at NIW I-140. There are requirements in the USCIS website. It will clearly say out what are the requirements for NIW, and you do have to meet the burden of proof. So as long as you ensure that you do produce all the documents that they request, your chances are minimized. Same thing with H-1B. So for H-1B, you do have to show that you have an US equivalency of a right degree. So upfront, if you want to reduce your RFE, one thing we suggest is upfront go ahead and put the education evaluation if your employee has a non-US degree. So a lot of times our clients will come back and say, no, let's go with the degree because it costs money to get an evaluation done. And sometimes we just go ahead. Sometimes we don't get an RFE. Sometimes we get an RFE. So if you're talking about how to reduce the risk of an RFE, there are some things that proactively you can do. Maybe get an evaluation done upfront. Maybe look at your occupation. If it is like a weaker occupation, maybe don't even file your H-1B, because sometimes USCIS could come and raise a major issue saying that it is not specialty occupation. So there are ways to reduce the risks of an RFE, and What you do is you look at the burden of proof for that particular classification, produce everything upfront as much as possible. And will that guarantee 100% no RFE? No. Sometimes, even if you do everything right, you produce everything upfront, sometimes USCIS still comes up with something because maybe they're doing some background check, maybe they're doing something on their back end, and the officer had some question. So they issue an RFE because RFE is not bad. All it is saying is the officer has some additional questions for you. So, yes, there are ways to minimize the risk, but you can never say that doing so is like 100% going to take my RFE chances away.
Thank you so much, Chand, for taking that up for Nidhi. And Nidhi, thank you for your questions. I hope you've got your answer. If you have more questions, please feel free to also join us on call. We are here, and this phone line is, available for you to join us. You can have a discussion with Chand, maybe a question. You can hear it from him directly. So why not call us up on this number 425-436-6335, and the access code they will ask is, and that's when you dial in 988-888. Just say hello after that. We will be able to hear you. Now let's take up Raghav's question. We have He's on YouTube asking, as an employer filing an H-1B for a highly skilled worker, what can I do upfront to avoid an RFE? Are there specific job descriptions or salary levels that draw more attention?
Yes, definitely. I think job description and the salary level, the wage level, definitely the officers, the first thing they do is they look at those things because that will determine a lot of things. So the first thing is to avoid an RFE. On the H-1B side, always look at your occupation. Okay, look at your job duties and look at what the Own It Online says. So if your job description is fitting that Own It code, fitting that the standard job description, you are probably on a good side. If your company is using an Own It code, but that job description it does not really match that Own It, you definitely could have an issue. So what we always say is always look at the Own It codes, look at Own It Online, and you have to be in sync. You cannot just randomly use any Own It code for any job description. The Own It code has to match the job description that you are going to be doing, and that job description also should be a part of that occupation as defined in Occupational Outlook Handbook or Own It. So it is a pretty easy thing to do. You can go online, you can Google Own It Online, or you can Google Occupational Outlook Handbook, OOH, and you can type in your occupation and it will show you the job description. For example, if you say you're a computer systems analyst, just put in Own It Online computer systems analyst or put in Own It Online database administrator. You will see the job description. And so that will tell you what is the industry standard. And then you look at what your company is saying is your job description. If they are in sync on a high level, if it is fitting that occupation, your chances are reduced. If not, USCIS could complain. That is one part. The second part is that Own It code even a specialty occupation Own It code or not? And again, that's another check that we do as a part of the filing. And Own It Online or even OOH, Occupational Outlook Handbook, they tell you what the job's entry level requirement. That particular occupation on a entry level does require a bachelor's degree, then yes, it is a specialty occupation. If not, probably have to go and see why exactly do you require a bachelor's degree. So there is more in-depth analysis to be done. More than likely, you might be hit with an RFE. So there are something called job zones, job zone 3, 4, etc. Job zone 4 or above typically are considered as specialty occupation jobs. Job zone 3 or lower are typically not specialty occupation jobs. So you can find this if you go to Own It Online. So if you go to Own It Online website, you will see it. And these are the websites that the officers also use. So that is one way. The next thing is wage levels. Wage levels will definitely draw attention. The reason is in 2017, when President Trump first took office, the first kind of RFEs that we saw things change were wage level RFEs. Lot of RFEs were issued about wage level one. Even like big companies, I'm talking about big companies like huge, the Fortune 10 companies. They saw RFEs talking about wage level. Why are you using wage level one? Justify wage level one. So if your wage level is low, definitely USCIS officer could talk about the wage level. Recently, I've seen RFEs where they even said wage level 2 is not appropriate, probably wage level 3. And some cases, I've seen cases where USCIS came back and said, no, it should be wage level 4. So definitely, if the wage levels are not appropriate to the job description, to the requirement of the job, RFEs will be hit. You will get an RFE. So one way to minimize these RFEs is make sure your job description, whatever you are, it is in sync with the industry standard ONET and OOH. It is also a specialty occupation ONET code, and then your wage level is calculated appropriately. So your employer, as a part of the LCA filing, a part of what they're doing is they're looking at the LCA wage levels very closely and ensuring that the wage level is what is the right wage level. If not, you can get an RFE. And I definitely think that we might see some new RFEs about wage levels in the future. The reason is we did see them in 2017-18 time period. They stopped in 2021, 22, 23, but more than likely I do expect some RFEs on wage levels in the future. So every company that is filing for H-1Bs, a very important thing that you are supposed to do is look at your wage levels. On the lower wage levels, especially wage level one, you have a lot of burden to prove that it is indeed an entry level wage level, because what everybody wants is, nobody wants the H-1B program to drive the wages of US employees down. So if the wage levels are not properly checked by USCIS, this program could severely impact the US workers' salaries. So for that reason, like the salary levels, the wage levels are highly important, which is why we always work very closely with the employers. And even the employers, they're typically very careful about the wage levels. They make sure they're paying the right wage level. If you do a mistake in that wage level, you file a H-1B, the H-1B will be denied. Sometimes you can't even fix it in an RFE. So you have to be careful. Even before filing the H-1B, your wage level has to be appropriate.
Thank you so much, Chand, for taking that up for Raghav. And we have Karthik Reddy back again with a follow up, so I think we should take that up. One of the beneficiaries received an RFE regarding experience letters. Consequently, they reached out to their former employers to obtain these letters, including details of their job responsibilities. However, the employers indicated that they were unable to provide this information. Additionally, the beneficiary lacks a point of contact for a co worker affidavit. So, what do we do?
Sure. This is one of the most, a common problem that I see. The beneficiary qualifications RFE, it's a very simple RFE. And a lot of times I have people, they come back and say, I did work for a long time. I have a lot of experience, and I can show you my relieving letter. A relieving letter that says that so and so is my title and I worked for so long in this company. The problem is, the challenge is the company will not attest to the job duties, like Karthik has mentioned. And sometimes you might not even find a coworker, because maybe back then you were in India, now you are in US, so you lost touch with your coworker. So it is even hard to get a coworker affidavit. It's a very common and a genuine problem. Unfortunately, the way USCIS works is they need evidence. So our claim is not enough. Our resume is not enough. So I cannot just put it in my resume and provide a simple letter with no job duties, and we cannot use it. Uh, but again, the good thing is, if you have a 4-year degree with at least 3 or more years of experience, that should be enough. So sometimes what we see is somebody has 10 years of experience, 4 or 5 years of experience, they're good because they're getting the experience letters. Maybe for like 1 2 years they're not able to get those experience letters. So what we do is, with whatever experience letters we have, we send it for evaluation and we ask the professor to see if that is enough. And most of the time what we hear is, if you at least have 3 years or more, you should be able to get an equivalency in computer science, information systems, and that is enough. So, but if you don't at least provide those letters for at least 3 years, you might have an issue. 3 or more. So, if you have a 4-year degree in civil engineering and then you have at least 3 years of work experience, you probably are okay, even if you're missing a couple of experience letters. But if you're completely missing all the experience letters, then it is a challenge, because the burden of proof rests on the petitioner. So if you don't show that evidence, your case will not get approved. And the good thing is, even if the company does not give, the employer might give. So on your side, try to document whatever you can. In the worst case, at least the offer letters and relieving letters and so on, worst case. But as much as possible, try to get an experience letter from your employer, or at least try to find some coworker that you worked with and have them attest to it. If not, if you have less than 3 years of experience, it could be a challenge. If you have more than 3 years of experience, then it is always okay to maybe leave that 1 year or 2 years of experience and move ahead without it.
All right. Thank you so much for taking that up for Karthik. And Karthik, I hope that you've gotten all your answers. And if you still have more questions, please feel free to join us on call. And the phone number is up there on the screen, 425-436-6335. And the access code is 988-888. And as of now, Chand, we have some more questions from our Facebook group. So I would ask Control to please display them, and let's take them up. So this first one is saying, "Hi, I received requests for additional evidence on my H-1B petition on the 27th of August this year, and documents were sent as response on the 10th of September. It has been 91 days since the RFE received. Still, the status is showing request for additional evidence as of now. Any idea on how much time it will take to update the status in the portal, and how will it get updated? Petition receipt date is 29th June 2024 for Texas Processing Center."
So, in general, looks like the RFE has already been responded in September. And what we see is anywhere between 1 to, I would say, 2 weeks. At least the status online should change and say the response has been received. So, if you see the status response has been received, then once the status changes, you're looking at about, say, 2 weeks to a couple of months. Some cases are fast, some cases take a couple of months. That is normal. In your case, however, what I understand is the status has not even changed, and it still is saying that RFE has been issued. If it says RFE has been issued, contact USCIS to make sure they do have the RFE. But if the status has changed and says RFE has been, the response has been received, then more than likely you're probably okay. And so I think, but again, this is what you can do. Either way, because it has been a couple of months, try to ask your employer or the attorney on record to create a service ticket. You can do it very easily. You can go and create this ticket with USCIS, create a service ticket, let them know that you have sent the response on 10th September. And that way, USCIS will at least get back to you and confirm that at least the case is in process.
Thank you so much, Chant, for taking that up. Let's go on to our next. And this is saying, "Hi, can anyone say what is the approval rate for 221G administrative processing?"
Sure. So whenever somebody gets a 221G for H-1B, what happens is more than likely Department of State is contacting the employer initially. Sometimes they contact a client if a client is involved. And the way these things work is if the employer is responding back properly with information about the definitive assignment. So they cannot say that their assignment is speculative. They have to provide proof that they have a definitive assignment for the employee. If the employers are answering back, replying back to Department of State, normally what we see is majority of the cases do get approved. The challenges that where I see is sometimes the employers don't respond to Department of State's verification requests. Almost all of the cases that go through 221G, most of the time, we see Department of State reach out to the employer directly, ask them a bunch of questions. If that is being answered on time, I would say majority of the cases will get approved. The challenges that we see are when the employer decides not to answer back quickly, or they take too long, or they are not able to answer with proof of a definitive assignment. That is when I see challenges. But most of the employers, whoever are responding back, it might take some time. Sometimes it could take a few weeks, sometimes a couple of months. But as long as the employer is proactively responding back, we do see 221G, and sometimes I see 221Gs take even up close to up to a year. Up to a year, sometimes it does take, and it is not uncommon. But what I suggest is wait for 60 days. So once you get it 221G and 60 days have passed, they have not taken any action. That is when you start reaching out to the consulate. And sometimes it means that every week you're reaching out to the consulate if they've not taken a decision. But the main thing is give them at least 60 days. Once you cross 60 days, then start chasing them and see what is going on. Again, the employer is probably the best person to chase the consulate. And normally, what employers do is they start initially, they also ask the attorneys to get involved. But again, if they are doing it, most of the cases do get approved.
All right. So, Chand, I'm very happy to tell you that we have a caller now. So, I think we should. Hi. May I know your name, please, and where are you joining us
Hi,
from?
hi Adil. This is Adil. I'm joining here from Houston, Texas.
All right. Please ask your question.
Sure. I'm on H-1B with H-1B stamped on passport, and my passport expiry date is 3rd of 2025. And now I have applied for a new passport, and also have a new H-1B transfer petition approved with I-94 ending on January 2027. My question here is, do I need to visit CBP office to correct my I-94, or does the new I-94 with the H-1B transfer petition is good to say that I'm not here illegally?
Hello, Adil. Thank you for your question. So I think in your case, what happened is you have an I-94, current I-94 from CBP that has a very immediate expiration date. But the good thing is you also applied for a transfer. And there is something called a last action rule. And according to the last action rule, what happens is whatever is the most latest I-94, that counts. And in your case, you have a transfer petition filed before your I-94 expires. So tomorrow when your H-1B gets approved, you will get a new I-94 on your H-1B approval copy. So on the bottom left, you will see a new I-94. And that I-94, because it is the most latest I-94, that will count. So you don't really have to go back to CBP as long as you make sure that you get a new I-94 on your transfer. So as long as your transfer approval on the bottom has a new I-94, you are completely okay. And in your case, more than likely, that is what will happen. You will get an approval. And when you get that approval, just confirm with your employer that you're able to see the I-94 on the bottom. If so, you're good to stay back. You don't have to go back to CBP.
Thanks, Chand. I already have my transfer petition approved, and I could see my I-94 date. The latest I-94 date as updated until 2027.
Yeah. In that case, because that is the most latest I-94, that is the one that holds. And because of that reason, you're good to stay back in the country till 2027.
Okay. Thanks, Chand. Thanks a lot. The anchor, and thanks a lot, Chand.
Thank you.
Thank you so much, Adil. It's really good
Thank
to hear from you, and I'm glad that you got your answers. I just want to ask, did you also comment as budding learner on our channel?
Yes.
All right. Thank you so much. Thank you so much for joining us.
Thank you.
Great. So Chand, I'm really happy about Adil joining in, and now let's go on to our next question from our Facebook group. So,
Mhm.
Control, if you could please display that. So I got issued 221G with yellow slip on September 20 this year, Toronto, Canada. Initially, no documents were asked, and in interview informed need more time to check the details. My project is for state client working for more than 5 years. Last updated date for changed for 7 times under 40 days. Ask the employment letter. Same is submitted date updated seventh time. Then it's been 20 days. Neither date is getting updated nor status is changing. It's really frustrating. Anyone have any clue what the processing time it takes? I moved country of nationality, waiting for the case status update. No update after document is submitted, and it's been a month and 2 days past.
I think what you can do is immediately have your employer mail out to the consulate. And simultaneously, what you can also do is maybe talk to your local congressman and ask them to get involved. Sometimes congressmen write letters to the consulate and ask them to see what's going on. And involving the congressman is probably also a good idea. So the first thing what I would suggest is have your employer reach out to the consulate right away and simultaneously also start working with the local congressmen and seek their help. A lot of congressmen are very helpful. They at least reach out to the consulate and ask them what's going on. And that is one way of getting some help. If you have submitted everything and they're not taking a decision, definitely involve local congressmen. And that a lot of times at least gets you at least an answer on what's going on.
All right. Thank you so much, Chand, for taking that up. And I think for now, this is it for our Facebook questions. I think I have a couple more questions, Chand, before we leave our show today. So, reflecting
Sure, sure.
on this year, 2024, how would you summarize, the key developments and challenges in the US immigration landscape? Just highlight a few, it would be great.
Sure. So the biggest major change that we saw in 2024 from an immigration standpoint, from a USCIS standpoint, is they increased the fees for everything. I mean, the fees went up drastically. And we're talking about huge increases for H-1B, H-1B amendments, premium processing. So premium processing right now is $2,800. And so they increased the fees a lot. This went into effect in April. After a long, long, long time, the fees was increased at USCIS. And unfortunately, the fees increase was drastic. The green card processing, that fees went up. We're talking about the government filing fee, the filing fee for I-140, the filing fee for 485, and the filing fee for EAD card. Everything went up. That was a very major change that did impact a lot of people. And another thing that a positive impact was the H-1B lottery. So last year and the year before that, we had huge challenges with multiple registration fraud, where people were trying to get unfair advantage in the lottery process. So USCIS, I think they were late, but they realized that it was a major problem. This year, they solved it. So what they did this year is they said, it doesn't matter how many companies file for you, we will just go with the passport. So it was a very welcoming change. It was one of those changes that I think really was a very positive change, because now that whole multiple registration issue was resolved. So that was a very positive change. And what that also meant is the number of filings, the registrations, they came down. That being said, there is still a very, very huge demand for H-1B registrations. We still saw about 400,000 registrations this year in the lottery. So what that meant is still there is a huge demand for new H-1Bs. And but USCIS coming back and fixing that lottery process was a very positive thing. Another positive thing that happened in 2024 for a lot of H-1B folks is Dropbox. So USCIS, so Department of State, the consulate, they have been continuing the Dropbox process. So everybody that had a visa in the past, either an F1 visa or a B1 or any kind of a visa, they're able to really utilize the Dropbox feature. Dropbox is definitely a lot more faster and a lot more convenient than going for an interview, visa interview, and all that extra hassle. So that has been a positive change. So overall, I think the main challenge we did see was the fee increase. The fee increase was substantial. Other than that, I think other things were probably on the positive side.
Thank you so much, Chand, for highlighting those positive changes we had this year. And I'm very happy to tell you that Karthik Reddy has actually joined us on call. So, Karthik, where are you joining us from?
Yeah, hi, Nipasa. Hi, Chand. This is Karthik from Hyderabad.
Hi.
Please ask your question.
Yeah. So my question here, one of my beneficiary got in a 221G, we file, from H-1B in the control process from India. And he received a 221G and we got a mail from visa officer and we responded them in a shortly manner within the 2 days, to the visa officer. My question is here, what are the answers we given or we responses to the visa officer? If visa officer, she or he, not satisfied with my answers, what will be happens? And then the next.
Yeah. So two things will happen. One, they're satisfied and they will say, okay, submit the passport and the visa is issued. The other thing that will happen is down the line, they will say that visa has been refused. And what they'll do is they will send a recommendation to USCIS to revoke the H-1B. So after a few months, if they're not taking any action, at some point of time, they will definitely change the status and say that the petition has been sent back to USCIS with a recommendation for revocation. So that's what happens. The worst case is it goes back to USCIS with a recommendation for revocation. And then what happens is USCIS will issue a NOIR, notice of intent to revoke. They will talk about what the consulate has found as an issue. You will get a chance to respond back. So you will get another 33 days, respond back to that NOIR. And if you're able to satisfy USCIS, they give something called reaffirmation. And if you get that reaffirmation letter, what you do is you again send the employee back to the consulate with that reaffirmation letter. And normally, when they see that reaffirmation letter, they typically don't cause a problem. They will issue the visa. So what? So the worst case is it goes back to USCIS. USCIS issues you a notice. You answer. You get a reaffirmation, and then send him back for stamping with reaffirmation document.
Okay, okay, got it. So here my question: if the notice of revoke was done for my employer, if the candidate wants to go to transfer with the other employer before traveling to US, is that possible?
So right now, because the approval is not revoked, so right now the transfer is possible. If if USCIS issues you a notice of intent to revoke and then eventually revoke that approval, then they will not be eligible. So right now, because he just has a 221G hold, so if he thinks that he has a better offer from another employer, he can always transfer and he will be cap exempt at this point of time.
Okay.
I mean, you are saying that before, unless or until revoke had happened, we can transfer. If the revoke happens, we can't.
Yeah.
That's it, right? The short answer.
I mean, theoretically, unless there is some fraud or misrepresentation in the current approval, he should not have any issue with the transfer. So just because he got a 221G does not mean anything, because I did see a lot of cases where somebody got a 221G and they were not patient enough to stay with that employer. They simply go to another employer and transfer. And we don't see any issues unless there is some kind of a fraud or misrepresentation happening on that first approval, where after you do a transfer, USCIS will come back and say that first petition had some misrepresentation issue, so you can't transfer. If not, he should not have a problem, because we did see a lot of cases where you have a 221G and they simply transfer to another employer.
Okay, yeah, got it. Thank you, Chand, and thank you, Nipasa, for the
Thank you, Karthik.
Thank you so much, Karthik, for joining us. It was really great having you join us. And yes, have a great day ahead. So thank you so much, Chand, also, for taking that up for Karthik. And, to wrap up our session for today, last but not the least, looking ahead at the coming year, 2025, what significant changes or trends, can we anticipate in the US immigration policies and, especially with the transition to the new administration under President Trump, though we've been talking about this over and over. Maybe you could just summarize a little bit.
Yeah. So I think the main thing is, I think people don't have to be very worried, because I mean, the H-1B program will not go anywhere. I mean, President Trump, he's still in favor of H-1Bs, as we saw from a lot of his talks. He does want specialized people to come to US. The only thing is compliance. So I think everybody, make sure you're getting paid. H-1B employees, the companies need to make sure they're paying their employees, because you might have site visits, this audits and checks. But as long as you're paying the employees on time, extensions, I don't think you'll have a lot of challenges. The only thing I think you have to make sure is you apply for the right occupations, because if you're trying to apply for an occupation just because the salary is low, or you're applying for a low level wage, those kind of cases I might see a problem. But in general, if somebody is highly qualified, they have a decent salary, I don't think those cases will have a problem. The challenges that we saw even in 2016 to 2020 were a lot with the wage level ones, low level wages, and those occupations that probably were not specialty occupation. Those, I think, were like the first targets. So I think the lessons learned is always make sure you're doing your prevailing wages right, you're paying the employees the right wage, and employees are not on the bench. So if those are done, I think things will be smooth. So I think, because we have lessons from the past denials, people are going to be careful about wage levels, because people now understand that wage levels are super important. The right occupation is super important. So as long as that is done, I think people will be good. Just make sure everybody's in compliance with their LCAs. Every H-1B will have an LCA. As long as jobs are in compliance with the LCA, I don't think we will see a lot of surprises. Things might get a little bit more stricter. There might be more site visits, but anybody that is actually working, getting paid, I don't anticipate a lot of issues for those folks.
Thank you so much, Sean, for doing this. And we spoke about this topic, H-1B RFEs for 2 episodes, and it was such a great discussion, so enlightening. Thank you so much. And folks out there, I'm sure you also want to consult with Attorney Chand Parvathaneni. So why not call him up? You can call him in his number, 817-523-8247. And you can even email him. And that is, his email address is law@spblawfirm.com, and go visit www.spblawfirm.com applicants.com to get to know more about attorney Chand Parvathaneni, all the way from Dallas, Texas, and also his law firm. Thank you, Chand. It was really great having you. I'm here wishing you a very happy end of the year and happy holidays ahead.
Thank you, Nipasa, and thank you everyone for joining us.
Thank you so much. Thank you, folks, for joining us, especially callers Karthik, and we also had. Sorry, Adil. Yes, almost forgot. But thank you so much for joining us on call, and also all you folks out there who participated in this conversation by commenting your questions. If you have resonated, please do not forget to like, share, and also subscribe to our channel. And we are Immigration and Jobs Talk Show on YouTube, LinkedIn, Facebook, and also on X. Connect with us, subscribe to us, hit that bell icon so that whenever we have discussions like these, you are also notified. And another best thing is that we are coming up in a short while, with a daily immigration dose here itself on Immigration and Jobs Talk Show, where you can join us on conversation with me and my co-host Sam. So yes, stay tuned on Immigration and Jobs Talk Show. This is Nipasa saying bye for now.